If you're getting ready to sign your first major corporate B2B client, or you're a nonprofit and you're looking at a high value government grant, your business or nonprofit could potentially be facing sort of a legal background check. And if your strategy for fulfilling that contract or complying with that grant relies entirely on a network of independent contractors, you could potentially fail all the background and due diligence checks before the deal even closes. And today we're going to talk about why. Now, if we haven't met before, my name is Maritza Shea Nelson, and I'm a small business and nonprofit attorney. I help entrepreneurs, founders, dreamers, and innovators pursue their passion without worrying that legal stuff, like the worker classification trap that we're going to discuss today, might come back to bite them. Often I work as an outside general counsel where my goal is to keep you ahead of the curve, not just react to crises that can threaten your bottom line. Oftentimes I'll see clients, they're getting started, they're operating very lean, it's a highly agile setup, they're bootstrapping their growth using the cash revenues that are coming in to kind of build up the business or the nonprofit. Maybe you're acting as a very high performing solopreneur, and absolutely nothing wrong with that. You keep things very casual, you keep your overhead very low, and you execute when and as the work comes in. And as things get a little bit busier, maybe you start to use a little bit of a close network. Sometimes this is hiring friends and family to work for you. Sometimes it's colleagues that you know pretty well that are willing to pick up a project here and there as a 1099. But as things continue to grow, right, you get that big commercial contract, you get that big corporate client, you get the government grant, whether that's federal, state, or local, you get the government contract if you're into that field. Your team size needs to expand a bit in order to keep up with the work, in order to actually fulfill those promises. And in order to do that without spiking your overhead expenses, oftentimes I'll see clients say, hey, I don't want to take that on. I'm just going to put together a group of independent contractors, a group of 1099s that I can rely on to deliver the core work that my company does or the core services that this nonprofit offers. What happens in these situations sometimes is that you get handed this stack of vendor onboarding documents, especially in the corporate world, or a huge, set of documents that you need to fulfill when you're dealing with government contracts or grants. And sometimes what we'll see kind of buried in these documents are these strict compliance requirements around, how the company operates, how the business operates, how the services will be fulfilled. Sometimes we'll see this buried in representations and warranties, which is a lot of legalese that I find clients very easily kind of skim over and don't worry too much about. But essentially, what this stack of documents will do sometimes is require you to basically promise, either under penalty of perjury or under the threat of a breach of contract or a fraudulent inducement type of claim, that your business or nonprofit complies with all federal wage and hour laws. And if you get this wrong, the client can, at best, pull the contract. Sometimes with my nonprofit clients, what I'll see is that the government contractor grant will freeze the funding, or worse, even require you to pay back the funding, or in really bad cases, even sue for breach of contract because you lied in order to get the contract. One of the things we're incredibly worried about, at the time of this recording, particularly in the world of government grants and government funded contracts, is that if they catch you in one of these lies, they can use that to pursue something called False Claims Act litigation. And with nonprofits, there's always the threat of potentially losing that tax exempt status or that being used as a weapon in the current political climate as an argument to try to take that tax exempt status away. When I'm talking to clients about, 1099s versus W-2 employees, most people, entrepreneurs, founders, business owners, nonprofit directors, seem to understand the idea that, well, if you're an independent contractor, I can't control how you get the work done, when you get the work done, right? We kind of intuitively understand what we call in the legal world the right to control. And we understand that independent contractors are supposed to be independent. So I don't tell you when to work. I don't tell you your hours. I don't give you a performance review. I'm not very closely tracking metrics. As I often put it, you're not telling your independent contractors what to do, when to do it, where to do it, how to do it. But under both the Fair Labor Standards Act and even Ohio's wage and hour laws, courts and regulatory agencies can also take a really close look at whether or not that worker is integral to your business or nonprofit. And so you might see agencies like the Ohio Department of Job and Family Services come in and do an audit, and they're not just asking, is the worker truly in business for themselves? But they're also looking at whether or not that worker is performing duties that are at the very heart or the very core of what your business sells or the services that your nonprofit provides. So, for example, if you are a software as a service company, but you rely on a network of independent contractors to develop the software, maintain the software, keep it running for clients, do all that behind the scenes tech stuff, well, that's at the core of your business, right? They're integral to what your business does and how it continues functioning. They're likely to be considered employees and not 1099s. We see this with marketing companies, right? You're a marketing agency, you deliver various brand assets, website development, business cards, logos, right? The whole nine. But all of that is actually being delivered by a network of independent contractors. Well, those folks are integral to what your business does. And in order for it to keep functioning, you need those contractors. Again, they're likely to be considered W-2 employees. So at the end of the day, a contract means absolutely nothing if in reality, that worker is performing services that are at the core of your business or nonprofit. And that's the piece of it that I think people tend to glaze over. So let's look at a real world example. In 2013, there was a case here in Ohio, Solis versus Cascom Incorporated. And that's a really good example of how worker misclassification and liability can be looked at under the Fair Labor Standards Act. In this case, Cascom Incorporated was a cable installation company, and they had made all of their actual cable installers independent contractors because, like so many small businesses, they did not want to deal with overtime and record keeping and all the stuff that comes with having W-2 employees. I would imagine that they did not want to have, the payroll expenses and payroll taxes. And now we got to pay for a big, expensive employee handbook, and we've got to train people, and we've got to do all of those things. Well, the Department of Labor of this and came in and did an audit and actually sued both the company and the owner. And when the court looked at it and applied the economic realities test, they came to the conclusion very easily that these installers really should have been employees. They should not have been treated as independent contractor, and you can't just slap that label on there to get around wage and hour laws. Well, what really made this case bad and what makes it a critical warning for the type of clients that I talk to all the time is that Cascom didn't track their workers' hours because they were independent contractors. And so when the court said, okay, how are we going to assess damages? They put a lot of emphasis on the employee's own testimony about how long and when they had worked. The Department of Labor considered statistical averages and used that to try to estimate hours. At the end of the day, the core result was the company was hit with damages of over $737,000 in back wages that these cable installers were owed. The court said, and you weren't acting in good faith, so we're also going to assess an equal amount of liquidated damages. And so the company ended up owing $1.5 million for misclassifying these workers. Well, here's where it gets even worse. On top of all of that, the case was actually against both Cascom and the company's owner, Julia Gress, and the court said you're both liable for the $1.5 billion. This is often what we call joint and several liability, which means we don't care whether the company or Ms. Gress pays it. One of you or both of you, however you decide to do it, are 100% responsible for the entire $1.5 million. At the end of the day, the business ends up going out of business. That's how the story ends. So, key takeaways when you're looking at some of these independent contractor issues and you're wondering why is it that, business attorneys and accountants harp on this so much? Well, the economic realities test is going to trump contract labels every time. Just simply having a piece of paper that says independent contractor agreement and, oh, they signed it. They didn't waive away their rights. The worker doesn't get to opt out of the Fair Labor Standards Act. So we really aren't that concerned about what you want to call it and what you happen to put on the piece of paper. Simply calling somebody an independent contractor does not make it so. The other big takeaway is that not maintaining accurate records, especially in wage and hour cases, the burden is always going to be on the employer to prove how much that person worked and whether or not they got paid everything that they were owed. Without tracking, courts are going to look at employee testimony, and I'd be willing to bet that employee is going to say, oh, I worked, 40, 50, 60 hours a week. We never got paid any overtime. The company wasn't keeping track of records. How are you going to fight that case if you don't have anything? And it's a catch-22 because you shouldn't be keeping track of hours if they're truly an independent contractor. But if your legal assessment is wrong, and they really were an employee, you absolutely should have been keeping track of hours. And this is why it is so incredibly important to get legal advice from an attorney that you know, like, and trust, and not just rely on what you heard on the internet, what you saw on YouTube, or what an LLM like ChatGPT told you. The third big takeaway is that the risk isn't just a big bill, right? In the Cascom case, they ended up owing those workers $6,000 a piece. $1.5 million is a lot of money for most small businesses. The risk isn't just that you lose the business, right? As the owner of the company, you can be personally liable for those wage and hour violations. So you didn't just lose your business. You didn't just lose your livelihood. Think about the impact of that on your house, if there's a judgment lien, on your personal bank accounts, on your retirement plans, right? That fancy vacation you had coming up. Think about what that really looks like in your business to get hit with a judgment like that. And that doesn't even take into account the legal fees that Cascom and Ms. Gress would have been paying to their attorneys to try to fight this. Cases like this easily go on 12, 18, 24 months sometimes, and you're going up against the U.S. Department of Labor. The fourth big takeaway is that proactive compliance is a lot cheaper than trying to remediate the problem, okay? The case doesn't tell us how much Cascom and Ms. Gress spent in legal fees and attorney's fees, but I can tell you from experience, litigation that lasts that long, I've easily seen clients spend tens of thousands of dollars, if not well into the six figures, fighting a case, okay? It's a lot cheaper to do this right than to try to fight the Department of Labor or the ODJFS or whatever other alphabet agency happens to be looking at your situation. And as we saw, acting in bad faith or failing to act in good faith can easily result in liquidated damages as well, potentially doubling the cost of what you actually owed the workers, plus what you paid your attorneys. My clients range from startups to growing businesses and nonprofits with nearly 100 employees across a wide variety of industries. If your organization is starting to scale up its delivery of services and you've been relying on a network of independent contractors, don't sign your next B2B contract, corporate contract, government contract, or grant award while you're still using these generic 1099 template agreements from the internet. Visit msnlawoffice.com/scheduling today, and let's sit down and really do a proactive workforce classification review and make sure that you're ready before risks like what we saw in Cascom find you. And once your team's classification is corrected, the next critical step is protecting your business or nonprofit as you scale by upgrading some of those core contracts. I'll see you in this video where I break down evolving your business contracts, a comprehensive guide to managing risk and scaling operations. Until next time.